as you guys know, most of you, what we're going to do is we're going to start with a specific topic, which is creating cash legacies. And then we're going to open up the floor for questions about cash legacies and how you do them. And then open up the floor for other questions about estate or anything that we can help you with. So these gifts, cash legacies, because they're a specific amount, once they're a specific amount, then they're an initial gift. And this assumes, so there's, I guess, to break that down, there's actually two places you could make an initial gift, cash legacy. You can make a cash legacy before the residue is determined. So that comes off the top and then the residue is divided. And the other place you could create a cash legacy is out of a segment of the residue. So you divide the residue 50-50, and then out of that first 50%, you give a cash legacy from to X. And I think we covered a lot of that with the when we talked about residue gifts. So I'm going to concentrate on sort of the simpler set of circumstances, which your client says, okay, I want to make a cash legacy of X dollars to this person. So that, because it's a specific amount, is an initial gift. So here we are with John Doe, and he has whatever assets he has. And we start with the scenario. And so as we're sitting with the client, we say, okay, so what do you want to do if your spouse is alive? And they say, well, I want everything to go to my spouse. I'll just get rid of this. This is sort of an old one. Let's get rid of, let's just give everything to my spouse if she's alive with no strings. So we can just do that. And there we go. We've created that first scenario. Now we go to the second scenario, and the client says, well, if my kids are alive, I want to make a gift to a person of a specific amount. So you would click on, you're in the initial gifts tab, click on cash gifts. And now, of course, you have those two choices. It's going to be either a gift of cash with no strings, or there's going to be a but attached to the gift. And usually on a cash gift, the but is you're going to stagger the payments, or you're not going to make it immediately payable. For example, it's going to be payable at a certain age. That's a classic example of a trust for a cash legacy. So let's take a simple scenario first. We want to make an absolute gift. So we click on absolute, and then we can select a beneficiary from the list of beneficiaries, and they come from the people tab, either family members or other members or other people that you've added. So they'll all be listed here, as well as the classes. So if you want to give a class gift to grandchildren, you can just do that, and it'll identify all of those grandchildren. And I'll talk about future members in a second. So that's how you'd make a class gift. You can either just type in grandchildren and then click on the class, or you can basically go down the list until you get to the classes. If you want to list an individual, then you can just click and pick the person that you want to leave a gift to. If you want to give it to someone who's not yet in the people tab, so it's somebody that is not in the family tree or that you haven't added yet, then you can click on the three dots and add a new person. And then you can just type in Kayla, and there you go. You don't have to put in a relationship, and then she will be added as the beneficiary. As soon as you add more than one person, you have another choice to make, which is, do you want that amount divided equally among the beneficiaries, or do you want it to go to each beneficiary? But before we get to that, let's go to the idea of the amount. We'll deal with that first. And let's just say we want to give $10,000 to Jordan and Michaela. Great. We can index that, which means that whatever $10,000 is at the date of the will is signed, it's going to be indexed in accordance with inflation. And I'll show you the wording that we use in the template, so that if you die 50 years later, it's not 10 grand, it's whatever 10 grand is now worth 50 years later. And then comes the division of that gift. So you can either divide it and make $5,000 to each of the beneficiaries. In other words, you're dividing it among the beneficiaries, or you can pay each beneficiary $10,000. So course, that's up to the client. What do you when they say, okay, I want to give Jordan and Michaela $10,000, you'll say, okay, do you mean each, or you want to divide it between them? So let's just go each. If there's some sort of condition, for example, they've already received money and you want to deduct that amount from that they've already received from their legacy, you can do that. You can attach other conditions as well. Typically, I wouldn't do that in an absolute cash gift, but you can do whatever you like. And then what happens if they're not alive? Well, does that gift go to their issue, or does it go to the residue? Or if you don't care, if you just basically say, look, if they're not alive, they don't get it, it just falls into the residue. You don't even have to pick residue as the gift over. You can if you'd like, but you don't have to. It will by default do that for a cash legacy. Okay. So that's how we add a legacy. And on your summary tab, it's going to keep track. So it's $10,000, but there's 2 legatees. So that's why it's saying, okay, when we're looking at what's left, we're going to deduct $20,000. It knows how many members are in that gift. Okay, that's how that works. Let's just try another situation where we have a trust. So we're say, okay, we want grandchildren, and we want them each to get 100 grand indexed, or you could divide that 100 grand among as many grandchildren as you have. But in this case, let's say each grandchild gets 100 grand. And then you set up the trust, because we want it to be trust. We might have a duration age 25, for example, and unlimited discretion, and a gift over to their issue first. And then if they don't have any issue, to your other grandchildren. That would be other class members equally. And that's how we would add that kind of gift. Okay. The next point I want to raise is this issue of cloning. Well, let's deal with copying first, and then we'll do the other. So let's say I want this gift. We're in the descendants only scenario, but let's say we wanted this gift in both scenarios. We wanted both if I have descendants, and even if I don't have descendants. So in the descendants only and in the no descendants, I don't have to do that whole legacy. I can just copy it too. So if I click on those 3 dots and I go copy to, I can copy it to the no descendants scenario as well automatically. Okay, that's a one-time copy. So if it'll just replicate that same gift. So if I go down into the no descendants, you'll see that same gift here. If I change it, it won't automatically change. So you've got to make sure that you sort of do that. If you want to change a gift, you should do it throughout. But that will automatically populate it in the no descendants scenario as well.
Just to clarify that, Jordy, please.
Yeah.
If you change the gift, should you delete it from the other scenario and then copy, or what's the...
Yeah, that's the right way to do it. Yeah.
Thank you.
Yeah. And the other point I want to make is why you want to use spouses. So in this case, there's a cash gift to Jordan and Michaela of $10,000 each, and both Janice and John want it. So it's important that I sync the scenarios, because, and I'll just remind you how you sync the scenarios. You go to the top right corner here with the sync button and you click sync, and yes, you'll do that. And then you'll want to also sync the, assuming that they want the same gift in both, you can sync it there as well. The reason it's important to sync is if you didn't do that and you drafted 2 wills for the people, there might be a possibility that the legatees would receive the gift twice, once under Jane's will and once under John's will, if they died within 30 days of one another, for example. And so we don't want that. And so what we do by syncing it, eState recognizes that both spouses have the same gift. It looks to see it matches gifts. And if it matches gifts, there's going to be a provision in the will that says the 2 wills have the same gift. If they die within 30 days of one another, it's only to be paid once. So that's why you want to do that. So then we go to the single will, and you don't need all this stuff, and we can generate. And in the meantime, while we're waiting, what, if any, are there questions? Well, never mind. Let me just show you what we got, and we'll open the floor to questions. So remember to always hit yes. We want to update the fields, and here's John's will. A couple things to show you about legacies. This is the clause. Oops, I just hit the wrong button. Let me just go to this button here. So paragraph Y, this is the indexing clause. So because there is any gift in the will that is indexed, this clause will appear in the definitions. And it says whenever there's a provision that says $10,000 comma indexed capital I, this is what you do with that gift. So it recognizes that. You don't have to remember to put that in. It will automatically do that. It's a pretty standard indexing clause against inflation. So then we go to, and of course, this is just your standard will that was generated. Here are the gifts. So there's $10,000 to each of Jordan and Michaela. Right? So that's what we've done there. You notice it doesn't say, gift over to the residue. It doesn't need to, because by definition, it says to each of Jordan and Michaela who is alive. They have to be alive. And if that gift, as we know with legacies, they automatically lapse and fall to residue. Especially, and if you've got, remember, the reason we include this is I think somebody raised the anti-lapse provision. So if I was, or Jordan or Michaela were close relatives of the testator, and we didn't have this clause, and they predeceased, it would go to their heirs. So that's why, as long as we have this who is alive at the survival date, that's a contrary intention. So we don't have to worry about the anti-lapse provisions that will pass that gift to someone other than the person we intended. And then we have grandchildren getting $100,000 each. Right? And again, it's indexed, and here's the trust for the grandchildren. And remember, we had the gift over, we had it to going to, if they died before 25, it was going to their kids, or if they left no issue, the balance divided among those of my other grandchildren who are alive per capita, right? And then we had a gift over to the grandchildren's issue if they predeceased. So that's sort of the legacies, the cash legacies. Now, just to show you these, this gift, just so you know how estate works. This gift, the grandchildren, was only obviously if I had issue alive. This gift was in both cases, right? If I had no issue, if I had issue alive, and if I didn't have issue alive. So what estate does is it says, okay, I want you to make these gifts. If I have issue alive, make these gifts. And then in the ultimate distribution, the no descendant scenario, right? No spouse, no issue, it repeats this gift again, okay? So the first one was conditional on there being issue, and that's why this was there. And if you don't have issue, it's repeated again because it's a different condition. So that's what, that's how these initial gifts work. Why don't we open the floor to questions on initial cash gifts? If there are any. Does that make sense to everybody? They're pretty, hopefully they're pretty straightforward.
I just didn't read this in detail yet, but just to clarify, you've got the two scenarios. If the spouse is not alive, Jordy and Michaela get 10,000. If neither spouse or
yeah. So the way the will is drafted, it says, okay, under these scenarios, I want you to do this. So this is under scenario if my spouse is not alive and if I leave issue alive. Okay. If those two conditions are met, then I want you to do this. Okay. Now this scenario, the no descendant scenario, is if I have no spouse and no issue, then I want you to do this. Pay this amount and then deal with the remainder.
Okay, so the fact that the ultimate distribution kicks in if no spouse, no issue.
Correct.
The prior one, if no spouse and issue, is automatically not effective. So there's no doubling up here. Okay.
Exactly. Yep. And that's how estate works, because you could have all different kinds of, you could have different gifts in different scenarios. So that's why it's done that way. Anything? That's a good question though. Thanks. Other questions about initial gifts?
I have a question, Jordy. It might be, it might go into legal advice territory a little bit.
No
but,
problem. We'll do our best.
Okay. So in this case, just to give you a background, it's a blended family. A wife and husband live together in the house. The husband bought the house. There's no mortgage.
Yes. Right.
And so the wife was saying, if he passes away first, yes, the house will be like it's a joint tenant. Joint tenancy.
Yeah.
So it goes to her. But she says, if I pass away, I don't want to give it to my son. I want to give it back to his children.
Right. So that's fine. So you would say, okay, in this case, it would go to John. It's John's house. He gives it to Janice. It's joint. So it's going to go to Janice automatically if she's alive. So now we're just dealing with John. If Janice is not alive, what do you want the home to do? You want the home to go to, let's just say, I don't know, you want it to go to, Thomas. Okay, great. Okay, that's what happens in that scenario. Now for her will, she's going to have the home because it's joint, right? Mm-hmm. So let's just put him in here. So so that'll be what happens if, I'm sorry, this is wrong. We got that. I'm in the wrong scenario. Okay, so here we are in Janice, and we're talking about the surviving spouse. And the surviving spouse, John, is getting the home if she dies first. But you're saying now, in the descendants only, so this is if John is not alive, what do you want to do with the home? Well, I want the home to go to, and then you just say, whoever it is, it's, Holly. Okay, great. That's all.
Okay.
So just go scenario by scenario.
Okay. My concern though, so the children are not Canadian residents. So I was wondering, is it better, it might be better for them to sell the house and just get the proceeds. So is there a better way to include that?
You could direct that they sell the proceeds.
Okay.
Yeah, sell the home and divide the proceeds.
So you would add that as a provision or condition or?
Yeah.
Okay.
You could say that. Yeah. It's one of the things on our list. When you create a gift of an asset, you're going to have the option to direct the sale or not. So we recognize that might be some planning that you want to do. So we're going to have that built in at some point.
All right. Thanks, Jordy.
Yep. Any questions about, as you guys know, we're starting to charge in September the 8th. And if you haven't been in touch with one of our team members about what plan you want, because we have now an unlimited plan with a pretty big discount if you sign up before September 8th. And the idea really is to enhance and encourage people to use eState for every client. And so by not charging per client, by having an unlimited plan, it doesn't cost you anything to do that for every client. And that does, as we all know, consistency in your process is important from a liability point of view. It's important just from a peace of mind point of view. And there are a bunch of reasons to do that. So whether it's a simple will that you can create in 4 minutes or a more complicated will, the idea would be with an unlimited plan that you start every client, because often, at least in my experience, you don't know, they come to you and they tell you, oh, this is going to be a simple will. And then we know that that's not necessarily, that's what they think, but that's why they're coming to us. And so when we build out some of the options, they're like, oh, I didn't realize I could do that. And then next thing you know, it's complicated. And so the idea is to make it as simple as possible and use the same process for every client. And our unlimited plan makes that helpful. So, so that's that. James, I'll get to your question. I'm just going to read it in a second. Any questions about the pricing stuff? If you have, I'm not necessarily the best guy on that, but if anybody's doing that, I think we worked it out. And if you have 3 will clients a month, you're better off with the unlimited plan, which is I think $249 a month, unlimited, and we're adding some premium features that you'll normally have to pay for, but if you sign up, they're going to throw those in, and that's going to be amendable templates. So you'll be able to amend templates and branding. We expect to have in there as well, so that your firm name or your name will appear on documents and summaries and things like that. So those are 2 features that people have asked us for, and so we're working on those. Why would one allocate the legacy asset home, then direct sale in cash legacy versus residue? You might want the residue to go to, so in this scenario that we just did, I showed you how you could do the home going to some, like, for example, this might be John's kid, Holly. Well, Janice might want her residue, the residue going to her kids, but the home going to someone else. And that's why you would do it differently and not have it in the residue. And that's not uncommon in a blended family situation where you say, this house I inherited and it really should go back to the family of the first to die, sort of thing. But I want the residue, everything else, to go to, my kids. So that's a common sort of thing. And of course, with the direction, I mean, there's nothing, even if you leave the home to Holly here, Holly can direct the executors without, probably without much of a problem to sell the home and just give them the proceeds. They might have to consent to the sale, but so that's another option if it's from a tax point of view. Because that's the other part of this, like directing the sale, is great if you know that the people when you die are going to be U.S. people, or they're not going to be residents, or whatever reason you're planning. But circumstances change, and now you've directed that they sell it. Might not be a good idea to sell it. So that's the risk of directing, putting specific things in, and that it's, a snapshot, right? We're trying to plan for the circumstances right now. And that's the idea that circumstances change. That makes our job, that's the hardest part of our job is, if we knew that the person, this will was kicking in next week, it would be much easier. But trying to contemplate all the different possibilities is what makes estate planning and wills tricky, and why, just to go on a little bit of not a rant, but just, I think we have to be careful that we're adding value to our clients, because we're seeing certainly these online will maker websites where you do your own will, being very successful. And there's going to be always a market for that. But I think what we as lawyers have to do is make sure that we're showing that there's true value in the advice that we're giving. It's not just the document that gets generated, but it's the advice to get you to the document that really is where we add value. So, any other questions?
I actually have another question, Jordy.
Great.
Okay, so very similar scenario. The husband wants to leave. He has a GIC account in cash, and wants to leave it to his wife for her life, kind of. And then the balance, like upon her death, to go to his children. So I was thinking a trust, like an initial gift, and then held in trust for the wife.
That's exactly right, because it's a gift with a but, right? You get it, but when you die, it goes somewhere else, right? So that's the definition of a trust. And so, if you had an asset here, a GIC, for example, let's just add a GIC. And now you're going to go into the same issues that you would have, with any sort of trust. So you go, okay, a GIC, I'm going to do that, and I'm going to pick a trust, and it's going to be for Janice, who's the wife. And I don't know who the executors are, and it's going to be till she dies, and it'll be discretionary. And then the gift over is going to be to Maybe it's to the client's issue, right?
Right.
And there you go.
Okay.
So that you had exactly that was the exact right, thinking. Yeah, and I did an article, which I just want to show you. It's really one of the areas that causes, and I've mentioned this before, but it's really a good one to just go back on and make sure that you've covered off. Hopefully, eState's made to try to avoid these errors, but these are, clients often come to us and say, oh, I got a great idea. I'm going to give my GIC to one person. I'm going to give this property to that person, et cetera. And there's, 5 really big problems with asset gifts. And, there's the idea of abatement. What happens, really, it's really redemption. If there's no assets there, that asset doesn't exist anymore. There's problems with that. There are the idea of equalization. So one asset goes up in value more than the other. And now you've got these beneficiaries who they thought at the time were being treated equally, but they're not. There's income tax issues. There's the debts that are associated with assets. So yes, they look like they're the same value, but in fact, one has a mortgage and the other doesn't. And then there's all transactional costs and how those are going to be borne. So those are really some big issues on asset gifts. So again, red flags. You can always find this on our blog. There's 5 big issues with problems with asset gifts. And I'd raise that anytime you've got a client who says, I got this great idea. I want this asset to go here. And it's like, okay, but do you realize that you might not have that asset? Do you realize that this might happen or that might happen? What happens then? So my personal view on that, just to jump through, if a client says, I want this GIC to be held in trust, I'd say to them, forget that. Don't do that. You're probably not going to have that GIC when you die. And what then? So why not pick an amount? What's the GIC worth? Oh, it's 250 grand. Great. Set aside 250 grand, put that in a trust. Who cares where it came from? It's the amount that matters, right? That's for those are my 2 cents on those kinds of gifts. And we're
Ready?
just approaching 1 o'clock. Yeah.
I just had 2, it's here, and I have 2 questions,
Sure.
not related to what you're talking about today.
Sure. No problem. Good.
But one was that you did mention just now about the templates. Does that mean that you'll be able to access uniform paragraphs about like cottages or spousal trusts or education savings plans? Or what do you mean by templates?
Yeah. So right now, when you generate the document, it comes up with our wording, and you'll be able to say to us, I don't want this paragraph wording. I want this paragraph wording in that situation. And so you'll be able to amend the wording in the template.
Okay. And then my next one is, as a practice with the will guides and the power of attorney guides, do you include those with the documents that, like with the affidavit of execution, do you include it with that? Like, so the will that you're going to be saving, the original one, like I've been keeping it separate. So I guess my question is.
Yeah. So the will guide, I only generate when I send it's only for the clients when I send the draft out so that they can refer to it when they review the will.
Yeah.
And I don't send them affidavits of execution or anything like that until I sign it all up. So the guide, yeah. And so the guide, I just delete it before we're ready to sign it.
Okay. I just wanted to clarify that because one time when I was trying to print some things, it was just, I guess I should have just unclicked that, but.
Yeah. So if you don't want the guide to print, right, you just
unclick it.
Unclick it, right?
Yeah.
So typically when I generate the first time, I have the will guide because I want the will guide. But if you don't want the will guide, you don't have to have it. But so I want the will guide because it's going to be in my first draft that I'm going to spend a few minutes editing and getting ready and then sending out. And I want that to go to the client. And then typically I work on that one version. And then when it's, once I've sent it out and we've reviewed it and we're ready to sign, I just delete it from the Word document.
Okay.
Does that make sense?
No, it totally makes sense. I just was thinking about the other night about whether or not, it would be good to have a copy of the will guide kept with all the documents just so it shows how you went through it with the client.
Yeah, I keep it. Yeah, I mean, for sure I send it to the client. So I have a record that I've emailed the will and the guide to the client. Yeah.
Okay. Thank you.
The other thing I have that I use is a will review checklist that I use to when I'm going through a draft with the client that just says, okay, did I discuss this? Did I discuss this? It's a bunch of basically just boxes that so I keep that in the file to say, okay, when we had our review meeting, this is what we discussed. I went over these paragraphs. I did this, I did that, did the other. Now I record my meetings, so that's less important, but although I like to have it there. And I write down any special discussions we had about a certain topic or any changes that I need to make. And I'm happy to show you that, send that to you if you like. If anybody wants that, just flip me an email and I'll send you, it's called a will review. I call it a will review checklist or something. And it's very comforting when you go back and can see what changes you wanted to make from one to another. And they're all in one little place and you can go down the list and know what changes you made. So that's why I still do it, even though I'm audio taping or I'm taping recording those meetings.
Jordy, we had a couple questions about U.S. gifts, etc. Is there anything that is triggered by if the beneficiary is a U.S. resident in e-state, or is there anything else we should be looking at
Yeah, I mean,
planning?
there is a warning that says you've got a U.S. resident who's getting a gift. It's not, I mean, again, it's not a huge issue if it's a relatively small amount. Right. If you're giving them, $10 million, that's a bigger issue. And I think it's really all that e-state can do is remind you, oh, you've got a U.S. person. You may want to get U.S. advice or tell the client to get U.S. advice. I think that's what I would do. I can't tell them, oh, you've got a major issue here. You don't have a major issue. I can just say, look, you got a U.S. beneficiary. If you want to, there could be issues there. And if you want to talk to a U.S. lawyer, I'm recommending that you do that, but, and you could say from my experience, I'm not giving you advice, but from my experience, it's not, I mean, you can be a U.S. person and receive money. There's no problem with that. So that's, I mean, unless you're going to start giving U.S. advice, and I'm very reluctant to do that, but some things that we've got, like if you give shares in a private corporation, right, that's going to be an issue. So if you direct a specific bequest of shares in a private corporation to a U.S. person, that there's going to be could be a bunch of issues. And we are looking into U.S. version and planning. So, that's not going to be done in the next short period of time, but it's something for sure that we've thought about and considered. So guys, I'm happy to stay on, but if for anybody who has any specific questions, but that's the end of our formal part of the program. So thank you all for your attendance.
I have one question, Jordy, if you don't mind.
Sure. Yeah, sure.
I was talking too much today, but
no worries. That's what it's for.
Okay. So this client has a son who has addiction issues, and she's saying he's a residuary beneficiary. Yep. But she's saying, I want to put a provision to make sure that he's been clean for 1 year, and like maybe a doctor, like a drug test or a doctor's note or something. So when I try to put this provision in the, like I created a residue for him.
Yeah.
Not a cash gift or like initial gift.
Yeah. Got it. Yep.
And put it in trust.
Yep.
But I don't think I've seen the provision I put or like the condition.
Yeah, we don't have a condition for drug testing in e-state.
I know, like I put something in there.
Right. Yeah. So yeah, I mean, the way let me just try to think through this. So we'd go add a gift to, Thomas and in trust. And now what happens if he fails that drug? Like he can't get that in a year?
I guess the money is kept in trust for longer. That's a good question.
Okay, so it's really the duration is death or some other condition, which is, you know, a drug test, clean drug test, right? You know, after a year or something. Oops, let's just do first clean drug test after a year.
So I think she's saying that he's been clean for 1 year. So like even if that happens right after her death.
Okay, so yeah, so I don't, whatever, however you want to draft that, you know, but it's going to be a trust, and it's going to continue for that. Now you're going to need to draft that out, but as far as that specific provision, but Eastate would say, you know, it's the earlier of his death and the first clean, however you want to put that in.
Okay. Okay, so I guess my difficulty was putting it not in the duration. Like I put the provision somewhere else, and
as a condition. Yeah, it's really. But if you think through it, like I think it actually is a termination event of the trust, because that's why I asked you what happens if he doesn't. Right, we need to maybe at that point the gift lapses. Right. I mean, I don't. That's what you have to sort of.
Okay.
You know, but this is the idea. I think that it's terminated. You know, on the death or the first clean drug test. Right.
Mm-hmm. Okay.
So, and this just says, you know, if he's alive, he gets it. But, you know, if he's not alive, which means it's caused by his death, then it goes to his kids or whatever. So that's what I think.
Okay. Thanks, Dorothy.
Right.
I had a question. I don't know. Is there going to be, do you think, and I've been writing this in sort of just by taking the Word document, but is there such a thing as a statement of principles? I've had a couple of wills where people come to me and they say, I know that this is going to be controversial. I know that somebody's going to fight this. And they want to have a statement where they say, in due consideration of the fact that I have 3 children, and normally I would divide everything 3 ways, but one of them has been suing me for the last 10 years.
Yes.
Or, you know, one of them, you know, I'm dividing things up this way in an effort to be fair, on the assumption that these assets will be equally divided.
Well, just add that. I mean, I would just add that at the end of the will.
Yeah.
Obviously, we couldn't. Yeah, I mean, what Eastate does though is it recognizes if children aren't treated the same, it puts in a forfeiture clause. Now, that might not be what the client as a sample, right? I don't know if this one did that because I don't know if we treated children the same or not, but I guess we didn't. But the point is that so it will do that. But then if the client wants to put in more, you know, reason for excluding and all of that, then just, you know, I think that's something you just put in.
Yeah, that's what I've been doing. I just wondered if there was going to be a sort of,
I don't
like
think
to put
so.
in some kind of statement of principles thing here, but.
Yeah, I mean, I'll be honest with you, that's a sort of an unusual circumstances. There's no way to sort of put in all the wording that a client might want, especially a statement like that. You want it really to be bespoke. So, you know, I would just add another paragraph and put it in.
I keep running into people who are expecting trouble.
Yeah, and you know, that's, you know, here's my, you know, whatever you want to call it, after due consideration, you know, whatever, and just add it as another paragraph.
Okay, thank you.
Yep. The bigger issue is the no contest part. That's a legal part, because that's not really a legal part, but you know. All right. Well, thanks everybody.